Here is something almost nobody tells you. The single most expensive day in your family's financial life is not the day you retire. It is the day the first spouse passes away. Because on that day, a window quietly closes, and if you have not moved the right assets into the right place before it closes, the IRS, the courts, and the tax code can quietly take a huge slice of everything you spent your whole life building. Some families lose tens of thousands of dollars. Some lose nearly half of an account. And the worst part is, almost all of it was avoidable, with a few simple moves made while both spouses were still alive. I'm Henry Cole, and today I'm going to walk you through the 4 assets you need to look at right now before that window closes. Your home, your retirement accounts, your bank and brokerage money, and your life insurance. For each one, I will show you the simple mistake that quietly hands money to the IRS and the simple fix that keeps it in your family's hands instead. Now, before we go one step further, let me say this plainly. This is general information, not legal or tax advice. Every state is different and every family is different. So please use this as a checklist to bring to a good estate attorney or a tax professional, not as a do-it-yourself instruction. But by the end of this video, you will know exactly what questions to ask, and you will understand why waiting is the most expensive choice of all. Here is the hard truth. When one spouse dies, the survivor does not just lose their husband or wife, they often lose their tax status. They lose one of the 2 Social Security checks. And they can lose control of accounts that suddenly freeze. The married couple that paid very little in taxes can become a single widow or widower who owes far more on the very same income. The tax code does not slow down to grieve with you. It keeps moving. So the goal of everything we talk about today is simple. We want the money to pass to the surviving spouse and later to your children, quickly, privately, and with the smallest possible tax bill. We want to avoid the courtroom. We want to avoid the frozen accounts. And we want to avoid that surprise tax letter that arrives months after the funeral. Stay with me to the very end, because the 4th asset is the one that trips up the most families, and the mistake on it can cost the most. Let us begin where almost every American family holds the most value: the family home. Before we touch the 4 assets, you need to understand 2 ideas. Master these 2, and everything else today will make sense. The first idea is called the step-up in basis. It is one of the most powerful tax breaks left in the entire code, and most people have no idea it exists. Here is how it works. Say you and your spouse bought your home 40 years ago for $50,000, and today it is worth $500,000. That $450,000 of growth is called a capital gain. Normally, if you sold, you could owe tax on that gain. But when a spouse dies, the tax code does something wonderful. It resets the value, what they call the basis, up to the full market value on the date of death. That reset is the step-up. Done right. 40 years of growth can become completely tax-free for the survivor. Done wrong, your family can owe tens of thousands of dollars in capital gains tax that they never needed to pay. And the catch is this: how you hold the title to your assets decides whether you get a full step up, half a step up, or none at all. We will come back to that with each asset. The second idea is one the financial world barely talks about. I call it the widow's penalty, and it catches almost every surviving spouse off guard. While you are both alive, you file your taxes as married filing jointly. You get the bigger standard deduction. You get the wider tax brackets. You can have a decent income and still pay a gentle rate. But the year after your spouse dies, the survivor usually has to file as single. Listen to what that does. The standard deduction is cut roughly in half. The tax brackets squeeze in. More of your Social Security can become taxable. And your Medicare premiums can jump because of a high-income surcharge called irrevocable. So here is the cruel math. Imagine a couple living on $60,000 a year, paying very little in federal tax. One spouse passes. The survivor may still have $50,000 of income coming in, nearly as much as before, but now they are taxed as a single person with half the deduction and tighter brackets. Same life, smaller household, and a bigger tax rate. The IRS does not send a card of sympathy. It simply moves the survivor into a more expensive lane. Now you can see why moving the right assets ahead of time matters so much. We are not trying to dodge anything. We are simply using the rules the way they were written, so that when that hard day comes, your spouse is protected instead of punished. Each of the 4 assets we are about to cover carries its own version of these 2 traps: a basis trap and an income trap. And each one has a clean legal fix. So let us start with the big one, the asset that, for most families, is worth more than everything else combined: the family home. Asset number one is your home. And for most families, this is where the biggest dollars and the biggest mistakes live. Let me start with the most common and most painful error I see. A loving parent, trying to make things easy, adds their adult child's name to the deed of the house while they are still alive. It feels generous. It feels smart. It is almost always a costly mistake. Here is why. When you add your child as a joint owner, you have legally given away part of your home as a gift. Their share does not get that beautiful step up in basis when you pass. So if they later sell, they can owe capital gains tax on decades of growth, a tax bill they would never have faced if they had simply inherited the home instead. On top of that, your home is now exposed to your child's problems. If they get sued, divorced, or fall into debt, a creditor can come after the house your spouse still lives in. Please, do not add your children to your deed without talking to an attorney first. Now, let us talk about the right way to hold your home between spouses, because this decides your step up. If you live in one of the community property states, places like California, Texas, Arizona, Washington, Nevada, and a handful of others, there is a powerful option. When a home is held as community property and one spouse dies, the entire home can get a full step up in basis. Not just half. The survivor could sell the next day and owe little or no capital gains tax. That is a benefit worth tens of thousands of dollars, and it only happens if the title is set up correctly. In the other states, called common law states, a home held in plain joint tenancy usually gets only a half step up when the first spouse dies. The survivor's own half keeps its old, low basis. That can mean a real tax bill down the road, when the home is finally sold. This is exactly the kind of thing a good estate attorney can review, and where the law allows, help you fix by adjusting how you hold title. The second move for your home is to keep it out of probate. Probate is the public court process that decides where your things go after death. It can take many months, sometimes more than a year. It is public, so anyone can look it up, and it can cost real money in court and attorney fees. In some states, those costs eat up a noticeable percentage of the estate. So, on a $500,000 home, probate alone could cost your family many thousands of dollars and freeze the home for a year for nothing. The cleanest fix for most families is a revocable living trust. You place your home, and often your other assets, into the trust while you are alive. You still control everything. You can sell, refinance, or change it anytime you like. But when you pass, the home moves to your spouse or your children privately, without the court, often in days instead of months. Some states also allow a transfer-on-death deed, a simpler tool that names who gets the house automatically when you die. So, for your home, 3 moves. Check how your title is held, so you capture the full step-up. Never casually add a child to the deed. And use a living trust or a transfer-on-death deed to skip probate. Get these right, and you may save your family more on this one asset than on all the others combined. Asset number 2 is your retirement money. Your IRA, your 401k, your 403b, and accounts like them. For many seniors, this is the largest pile of money they own, and it comes with a tax trap built right in. Here is the first thing you must understand. These accounts do not pass through your will. Let me say that again, because it surprises almost everyone. It does not matter what your will says. Your retirement account goes to whoever is named on the beneficiary form you filled out, sometimes decades ago. If that form is blank, out of date, or names someone who has already passed away, the results can be severe. So, your very first move today is to log in or call and check the named beneficiary on every retirement account you own. Make sure your spouse is the primary beneficiary and that your children or others are listed as the backups. Why does naming your spouse matter so much? Because a surviving spouse has a special power that no one else has. It is called the spousal rollover. Your spouse can take your IRA and roll it into their own, treating it as if it had always been theirs. The money keeps growing tax deferred. They take withdrawals on their own schedule. It is smooth, and it keeps every option open. Now here is the mistake that costs families dearly. Some people name their estate as the beneficiary, or they leave the form blank, so it defaults to the estate. When that happens, the account often must be emptied much faster, sometimes within 5 years, and every dollar that comes out is taxable income, Often in the worst possible years, you can turn a 30-year asset into a 5-year tax bomb with one blank form. For your children, the rules changed a few years ago. Under what is called the Secure Act, most adult children who inherit an IRA now must empty it within 10 years. Picture what that does. Say you leave a $400,000 traditional IRA to a daughter who is in her peak earning years. Those withdrawals stack right on top of her salary, pushing her into higher brackets, and a big chunk can go straight to the IRS over that decade. There is a powerful legal move to soften this, and it ties right back to the widow's penalty. While both spouses are alive and still in those gentle joint tax brackets, you can consider converting some of your traditional IRA into a Roth IRA a little each year. Yes, you pay tax on what you convert now, but once it is in the Roth, it grows tax-free, it comes out tax-free, and there are no forced withdrawals for your spouse. You are choosing to pay tax now at today's lower married rate instead of leaving your widow or your children to pay it later at a higher single rate. For the right family, spreading those conversions over several years can save a small fortune. So for your retirement accounts, check every beneficiary form. Name your spouse as the primary, so they get the rollover. Never let your estate become the default beneficiary. And ask a tax professional whether slow Roth conversions make sense while you are both still here. This is income tax we are talking about. And income tax is where the IRS quietly keeps its biggest share. Asset number 3 is your everyday money, your checking and savings at the bank, and your investment or brokerage accounts. These feel simple, but they hide 2 real dangers: the frozen account and the missed step-up. Let us start with the danger almost no one plans for. When one spouse dies, accounts held only in that person's name can be frozen. The bank locks them until the court sorts out who has the legal right to the money. Imagine it. The funeral bills are coming. The mortgage is due. And the surviving spouse cannot touch a large part of the family's cash because it was in the wrong name and tied up in probate. This is heartbreaking, and it is completely avoidable. The first fix is simple. Make sure the surviving spouse always has accounts they can reach immediately, either joint accounts or accounts in their own name, so that day-to-day life does not stop. Do not keep all of your cash in one spouse's name alone. The second fix is a small piece of paperwork with a big payoff. On your bank accounts, you can add what is called a payable-on-death beneficiary, often shortened to POD. On your brokerage and investment accounts, you can add a transfer-on-death beneficiary or TOD. These usually cost nothing to set up. You stay in complete control while you are alive. But the moment you pass, the account transfers directly to the person you named, skipping probate entirely. No court, no delay, no public record. It is one of the easiest and most powerful moves on this entire list. And most people have simply never been told to do it. Now, for your investment accounts, remember the step-up in basis we talked about. Those stocks, those funds, those shares you have held for years may carry large gains. How the account is titled decides how much of that gain gets wiped clean when a spouse dies. In community property states, holding the account as community property can deliver a full step-up on the entire account. In common law states, a jointly held account usually steps up only the deceased spouse's half. This is worth a real conversation with your advisor, because the difference can be thousands of dollars in capital gains tax that your spouse either pays or never pays. There is one more quiet trap here. Be careful about adding an adult child as a joint owner on your bank or brokerage account just for convenience, so they can help pay the bills. Like the deed mistake, this can expose your money to their creditors, it can count as a gift, and it can mess up the step-up. If you simply want a child to help manage money, a financial power of attorney is usually the safer tool because it lets them help without making them an owner of your money. So for your bank and brokerage accounts, keep cash the survivor can reach. Add POD and TOD beneficiaries to skip probate. Check your titling so you capture the step-up, and use a power of attorney instead of joint ownership when you just need a little help. Asset number 4 is life insurance. And this is the one that trips up the most families because it seems so simple. You bought the policy, you named a beneficiary. What could possibly go wrong? Quite a lot, actually. Let us start with the basic mistake, the same theme you have heard all day. Check who your life insurance beneficiary is and make sure it is a person, not your estate. When life insurance is paid to a named person, like your spouse, it usually arrives quickly, privately, and free of income tax. But if the beneficiary is blank, or you named your estate, that money can be dragged into probate, delayed for months, and exposed to claims from creditors. The same is true if the person you named passed away years ago and you never updated the form. So step 1, just like before, check the beneficiary, name a real person, and name a backup. Now, here is where life insurance gets powerful, and where bigger estates need to pay close attention. Most American families will never owe the federal estate tax because the federal exemption is very high, currently in the range of around $13 to $15 million per person. But here is what people forget. The death benefit from a life insurance policy that you own is counted as part of your estate, so a family that felt comfortably under the line can be pushed over it by one large policy. And several states have their own estate or inheritance taxes that kick in at much lower levels. In some states, as low as $1 or $2 million. At that point, the tax can take a serious bite. There is a well-established tool for this called an irrevocable life insurance trust, sometimes shortened to ILIT. In plain terms, the trust owns the policy instead of you. Because you no longer own it, the death benefit is kept outside of your taxable estate, and it can pass to your family free of estate tax. The trust must be set up carefully, and it is irrevocable, meaning you give up control. So this is absolutely a job for an experienced estate attorney. There is also a 3-year rule. If you transfer an existing policy into the trust and you pass away within 3 years, the IRS can pull it right back into your estate. That is exactly why waiting is so dangerous, and why setting this up sooner rather than later matters so much. Life insurance also solves another problem, quietly: liquidity. If much of your wealth is tied up in a house, a farm, or a family business, your heirs may owe taxes or bills, but have no cash to pay them, forcing a rush sale of the very thing you wanted to leave behind. A life insurance payout can provide that cash exactly when it is needed. And one more point for married couples with larger estates. When the first spouse dies, the survivor can claim the deceased spouse's unused federal exemption. It is called portability, but only if the estate files the proper tax return on time. Many families miss it simply because no one ever told them to file. So for life insurance, confirm the beneficiary is a person with a backup. Understand that the death benefit counts inside your estate, and if your numbers are large or you live in a state with its own death tax, talk to an attorney about a trust and about portability before that window closes. Now let us talk about the traps, because where there is money and grief, there are people and mistakes waiting to take a piece. The first is what I call the Free Living Trust Seminar. You have probably gotten the mail or seen the ad, a free lunch, a friendly speaker, and a warning that your family will lose everything unless you buy their living trust package today. Now, some of these are run by real professionals, but many are high-pressure sales events that sell seniors expensive, one-size-fits-all trust kits that may not even be valid in your state. Sometimes the real goal is just to get a look at your finances and sell you other products. A real estate plan is built for your family in your state by a licensed attorney you can call again next year. If someone is rushing you, pressuring you, or selling the exact same kit to everyone in the room, walk away. The second trap we have already touched, but it is so common, it is worth repeating. Adding your children as joint owners on your home or your accounts. It feels like simple planning, but it can trigger gift issues, expose your assets to your child's creditors and divorces, and destroy the step-up in basis that would have saved your family thousands. Convenience today, costly tomorrow. Use a trust, a beneficiary designation, or a power of attorney instead. The third trap is the silent one, the out-of-date beneficiary. People get married, they get divorced, they have children, they lose loved ones, and they never update their forms. I have seen life insurance and retirement accounts pay out to an ex-spouse completely by accident because a form was never changed. The will said one thing, the form said another. And the form always wins. So once a year, on a date you will remember, pull out your accounts and check every single beneficiary. It takes one afternoon, and it can prevent a true disaster. The fourth trap is thinking you are too young, too healthy, or too ordinary to bother. Remember the 3-year rule on the life insurance trust. Remember that beneficiary forms and titles must be changed while you are alive and well, not from a hospital bed. The entire point of today is that these moves only work if you make them before the first spouse dies. Once that day comes, most of these doors are closed for good. And the fifth trap is trying to do all of this yourself from a cheap website to save a few $100s. Estate law is deeply local. A document that is perfect in one state can be worthless in another. The few $100s you save on a do-it-yourself form can cost your family tens of thousands in taxes, probate, and court battles. This is the one area of your financial life where good professional help truly pays for itself, often many times over. Spend the money on a qualified attorney and a tax professional. It is the cheapest insurance you will ever buy. Let us bring it all together. Because if you remember nothing else, remember this checklist. There are 4 assets to look at right now, while both spouses are still here, healthy, and able to sign. The first asset, your home. Check how the title is held so the survivor gets the full step-up in basis. Never casually add a child to the deed, and use a living trust or a transfer-on-death deed to skip the long public probate process. The second asset, your retirement accounts. Your will does not control them. The beneficiary form does. Name your spouse as the primary, so they keep the spousal rollover. Never let your estate become the default. And ask whether slow Roth conversions now can spare your family a much bigger tax bill later. The third asset, your bank and brokerage accounts. Keep money the survivor can reach, so nothing freezes. Add payable-on-death and transfer-on-death beneficiaries to skip probate. And check your titling to protect the step-up. The fourth asset, your life insurance. Make sure a real person is the beneficiary. Remember, the death benefit counts inside your estate. And if your numbers are large, or your state has its own death tax, ask an attorney about a life insurance trust and about portability. Underneath all 4 is one simple truth. When the first spouse dies, the survivor can face a smaller standard deduction, tighter tax brackets, frozen accounts, and a court process, all at the hardest moment of their life. Everything we did today is meant to protect that person, the one left behind, from a tax system that does not pause to grieve. None of this is about being rich, and none of it is about dodging what you truly owe. It is about using the rules exactly as they were written, so that the money you worked your whole life to build passes to the people you love, quickly, privately, and with the smallest legal tax bill. So here is your one assignment this week. Pick just one of the 4. Pull out the paperwork. Check the beneficiary or the title, and then make an appointment with a qualified estate attorney to look at the rest. The window is open today. The most expensive thing you can do is wait. If this helped you, and you want more plain English explanations of the money and benefit rules that affect seniors, do me a favor and subscribe, so the next one finds you. Share it with your spouse and with a friend who needs to hear it. This is Henry Cole. Thank you for spending this time with me. Take care of yourself, take care of each other, and I will see you in the next one.